Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we at Digital Law are a niche law firm specialising in working solely in the technology and cybersecurity law sector. In each episode, we look at the recent stories in the news related to digital technology from around the world, with a specific emphasis on data protection and cybersecurity. For more information on the stories that we will be covering this week, please check the link in our show notes. And by way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright, and I'll let Peter introduce himself. We dive into today.
My name's Peter, I'm a solicitor and managing director at Digital Law, and we've got quite a mix of stories to take you through every week, from some fairly significant, massive finds to ongoing discussions around AI. So I'll pass over to Amelia to kick us off.
Thanks, Peter. So what are we going to be covering today? We are going to be looking at the UCL statements on AI in law school. We're looking at a law firm that has been fined £60,000, TikTok's fines, and yes, that is plural, the Co-op and MLS hack, government consultation on AI and copyrights, and then compensation company that has been fined £90,000. But before we kick off with today's stories, here's some background information on our podcast producer, Anson Evaluate. Anson Evaluate are a consultancy company offering a variety of services, including data protection training, outsourced data protection officer services, and specialising in advising clients over multiple jurisdictions. So, kicking off with our first story, the UCL statements on AI in law school. So this story is looking at how UCL are rejecting the use of AI in assessments. So our task as a law faculty is to ensure that our degrees are and continue to be both transformative educational journeys and powerful, internationally recognised and durable signs of our students' achievements. That's a quote from the story from Legal Tweak. And I think there's quite a lot to unpack here, more than just what UCL are saying. So Peter, I'll let you get your thoughts out there.
So basically what's happening here is that UCL are saying we're going to make sure that at least more than half of our assessments cannot be completed with the benefit of AI assistance. At first glance, you might think, well, why isn't it all of your assessment can't be completed with the benefit of AI assistance? But I think the idea is that they know that AI is something that lawyers are using in practice, and they don't want to totally stamp out its use. However, they don't particularly want students using AI for everything and not actually being able to develop the skills you need to be a lawyer. I think it's interesting that, of course, as fast as they're saying this, AI is developing and becoming more and more accurate and more powerful with every passing month, not to mention the volume of different platforms out there that are highly engineered with a lot of highly accurate content that's been used to train them continues to grow exponentially. But I think one of the key things here is the fact that the university is conscious that students are going to be using this technology and wants to make it clear that for a majority of their assessments, you can't use it and its use is not encouraged. And this comes down to being able to show that, look, our graduates will still have that ability to be able to critically think and have developed that on their own and not be relying on a robot to do their critical thinking for them.
I think there needs to be a balance here, because there are some real good uses for AI. For example, I know that myself and Peter were talking earlier, the fact that sometimes if I'm starting a project, and sometimes actually that's the hardest bit, starting a project. Sometimes AI can be really useful in signposting you or giving you somewhere to start. But I think that keyword start is the important bit, because that doesn't mean the start and end of the project. And that means it's signposting you in the right direction, giving you a little bit of creative freedom in terms of the project. It does not do the project for you. And I think that's the difference. And that's where, taking it outside of the academic realm, we've been doing work with our clients to create AI guidelines, showing you, giving the clients tools to say, well, this is when you can and cannot use AI. This is when it should and shouldn't be used. And just giving those boundaries, because I think if you've got clear boundaries in which to operate the AI, that means that you're able to be clearer and more transparent with those who are trying to use it.
And I think it's also a matter of also making sure that students know when they're using AI, because it's now embedded in so many different systems. I mean, Copilot is now embedded in Microsoft Office.
Yeah.
You've got some of the sort of grammar checker systems which use AI to then suggest, well, maybe that word isn't right, maybe the spelling isn't right. Guess what's powering that? AI. So if you're even just drafting your essay, then you pass it through one of those things. If there is a system the university is operating to try and work out, well, has AI been used on this text? Depending how you've done that, it may end up going, well, hang on, AI has been used here, even though you might have actually generated the text yourself. The fact that you then sort of got a little bit of a grammar check and a bit of help from the AI could then make some alarm bells somewhere start ringing with the assessment. So,
well, this kind of rings like when they do plagiarism checks. You know,
exactly.
There are tools out there that can evaluate whether a piece of writing has been completed with AI. And I think that's now, in some cases, what schools or academia is having to turn to check these things. Yeah, it's like, where is that line? Where is that line in the sand? Where does using a simple AI grammar checker that actually is an incredibly useful tool, particularly if you've got special educational needs or spelling isn't a strong suit like myself.
Yeah.
You know, having a grammar check in some way, shape, or form is useful. But where does that then edge on the, well, you're not allowed to use AI for that?
Yeah, exactly. So, I mean, this is a discussion that's going to go on. I think it's not just when it comes to the teaching of law. Obviously, I think there's a lot of concern out there about the use of AI across academia as a whole and its potential use in assessments. There are concerns over the volume of AI-generated media out there. And the fact that it may impact students' creativity and critical thinking overall. So this will be an argument that's going to run and run and run, but where we find ourselves at the moment is in the first steps of institutions like UCL having to make sure that they have the right rules and governance in place, given the technology that's out there.
Thanks, Peter. I'm sure this is a story we're probably going to be revisiting time and time again, because again, this isn't just one, this is UCL's opinion, you know, there are other schools that may differ in that. But
yeah, other schools are available. Yeah,
yes. But moving on to our next story, we are looking at the law firm Merseyside-based DPP Law Ltd that was fined after a cyber attack led to information being published on the dark web. So this was fined by the UK Information Commissioner's Office, £60,000. The law firm specifically focuses on law relating to crime, military, family, fraud, sexual offences and actions against the police. And essentially, the ICO investigation revealed that there were lapses in DPP security practices that left information vulnerable to unauthorised access. So, you know, you've got quite a lot to unpack here, particularly given that this is a law firm. But the other point worth mentioning is that this cyber attack happened in June 2022, and this cyber attack led to DPPP's data, about 32 gigabytes, being published on the dark web, which in of itself, that's a great deal of data. But DPPP did not consider that the loss of access to personal information constituted a personal data breach, so it did not report the incident to the ICO until 43 days after they became aware of it. So Peter, just for the avoidance of doubt for our audience, when should you be reporting a breach?
So he says with his head in his hands. For some reason, and we only find this problem with our law firm clients, they're the ones that when you tell them you've had a data breach, when they come to us with an incident like this, and we tell them, okay, you've got a data breach, you have to report it, it's always the law firm that quibbles. Oh, we don't think it's a breach. We dispute that. We don't think it's that. We think it's that. We don't have to report this. And you're like, well, you do. And this monetary penalty proves it. There are law tech platforms, case management systems that have been on the receiving end of cyber attacks in recent years. And when the law firms using them have contacted us, we've said, you have to report this. And they've gone, no, we don't want to. And it's going to be monetary penalties like this that's evidence that no, you do have to report this. For the avoidance of doubt, if a third party gets access to your confidential client information, or even confidential information about your staff, like salaries, training information, HR records, that's a data protection breach. No ifs, no buts. In this instance, this information was then breached online on the dark web. Maybe the law firm didn't understand what the dark web was. It counts in the same way, I'm afraid. And I'm sorry, I'm coming across being quite angry about this. It's because I am. And I only hope that by taking this action, law firms will realise You don't get to quibble and dance on the head of a pin like this, like the other wonderful discussions that I know that partners have that will last for hours. About everything from professional indemnity insurance to other issues about how they run their firms. But on this monetary penalty makes it quite clear there is not room to quibble and talk about it and think about it and examine your navel. If there is a data protection breach and you find out about it, you have 72 hours to report it, not the 43 days that it took these guys to get round to it. Because if you do take that amount of time, guess what? You'll get fined. £60,000 may look like not being an awful lot compared to other fines that we would be talking about even in the course of this podcast, but it's enough for a law firm in these days of tight margins for that to be a significant impact, for your average high street firm. That's the sort of thing that wipes out profit margins for a year.
Thanks, Peter. I think that's quite an open close discussion there because
you
know what, it's a clear fine, and I think we can both agree that they fully deserve that one.
Yeah, and the thing is as well, we actually don't have a huge number of precedents from the ICO in terms of monetary penalty notices where we can point and say a law firm made this mistake and this is why they got fined. In this instance, it's black and white. It's a great example. And I mean, I'm speaking at a number of conferences coming up on issues around cybersecurity, and this example will be front and centre.
I'd say this appears to be Exhibit A.
Yes.
Okay, moving swiftly on to our next set of fines. And hey, would it be a digital podcast if we didn't mention TikTok at this stage? No, it wouldn't. So we've got two related TikTok fines. Firstly, we've got the nice fine, pretty normal, 12.7 million, and for TikTok, that's pocket change. And that is around misusing children's data, and this is around the underage children that are using TikTok without parents' consent, hence the fine. Pretty standard. I think we've covered a lot in this podcast around the fact that there is not enough being done to protect children and their access to social media sites. Some of that being TikTok, other sites such as Facebook, Instagram, Meta Orange.
Yeah.
There is not enough being done, and this is being typified here by the ICO. But perhaps the more juicy story on this is the €530 million fine that the Irish Data Protection Commissioner has fined TikTok. And that's in relation to measures following an inquiry into transfers of European Economic Area user data to China. There are a lot of things that you can unpack here. So essentially, TikTok were already being investigated. There was already a formal investigation into TikTok and where data was being stored. And this is because of TikTok's ties to China. And I think we've done a lot on this podcast in terms of the issues in storing data in China. But essentially, TikTok gave particular evidence in the inquiry about the fact that European users' data was not being stored on servers located in China. However, in April 2025, TikTok informed the Data Protection Commissioner of an issue that it discovered in February 2025, where limited European user data had been stored on servers in China, contrary to the evidence TikTok had already provided them with. Therefore, this is where the problem arises. Peter, I'll let you continue with this.
Okay, so let's have a look at the smaller story first. The fine in respect of the UK ICO. That fine is levied in particular due to access to the platform by children under the age of 13. So it's estimated that 1.4 million UK children accessed TikTok in 2020, and that's what this fine relates to. They've said that since then, TikTok have invested heavily in stopping under 13s accessing the site. Good luck with that. We currently have a summer vacation students working in our firm, and I had a chat with them, and they said they were able to install TikTok on a mobile device very, very easily with the minimum of checks being carried out, and that was quite recently. So it wouldn't surprise me. I mean, this is a legacy fine. We know that the wheels of the ICO turn slowly, so there could be more enforcement in due course in relation to minors using TikTok. The concern is, of course, that then the data of children would have been used to track them, to profile them, and at no point was informed or parental consent properly sought. And that's what this really comes down to. There are just no steps, no effort taken to think about, oh, these are children, should we be treating that data differently? So that's where we are in terms of the ICO. We then have to look at this broader issue with regards to data as a whole from European citizens. The big reason for the large nature of this fine is that at one point TikTok had said, no, we aren't storing data of EU citizens on our servers in China. And then it came out that it did. And that meant that TikTok had given evidence to an inquiry that the Irish Data Protection Commission was carrying out, which then turned out to have been erroneous. So that's the reason why they'll have had something of a sense of humour failure on that point. Now, the point here, therefore, is that the Irish regulator is the lead regulator on behalf of all of the European data protection regulators, because TikTok's infrastructure and servers are located in Ireland. So they're the lead enforcer carrying out this enforcement. So it's a pretty strong shot across the bows from the European Data Protection Board until we bear in mind that in 2022, ByteDance, which is TikTok's parent company, made $80 billion in revenue in turnover.
Correctly.
That's £64 billion. So if you've made €80 billion, €500 million, obviously that would be a bigger impact on profit. What's left over. We're talking about turnover here, and that will have exponentially increased. I mean, that figure is from 2022, so I'm sure in subsequent years, ByteDance's turnover increased further. But it's still going to be loose change given the large resources now that tech corporations like TikTok have. So this is an example of the fact that we're seeing the sizes of these fines from data protection regulators increase. Will we actually see any meaningful change in behaviour from the tech platforms on the back of the monetary penalty notice?
That remains to be seen.
I'll leave that question hanging in the air, and I think that's one that we'll come back to in the future.
Thanks, Peter. So our next stories we've kind of combined into one big story. So this is looking at the Co-op and M&S cyber attacks. And there's quite a lot to unpack between those. So firstly, focusing on Co-op, staff have been told to keep cameras on during meetings because they have an idea that hackers might be inside calls and listening in on meetings. And sometimes, I think we're all familiar with video conferencing now. Every now and again, if you've got Wi-Fi problems, someone might not have their camera on it and literally just be their voice. And so actually, Co-op said, no, we actually need your cameras on to check your identity there. Then, as a result of the cyber attack as a whole in Co-op, there were warnings of course, fake IT calls from the organisations that have been urged to look into because there has been personal data breaches, and therefore, unfortunately, those poor souls that either shop, bank, or whatever with Co-op, M&S, there could be problems there. Moving on to then M&S, they are still somewhat unclear about the impact that this is having on its customers. Came out today that the data that was stolen included customers' contact details, dates of birth, and online order histories. However, the theft does not include payment details or anything that could be used to make payments. But this, this is a story that keeps unfolding, and we're still not yet certain on the depth of the issue here. Peter.
So the point here is that we've had two fairly major UK retailers that have been impacted by a series of massive cyber attacks. I think for the first time we're seeing, we've seen with the big attack, well, it wasn't an attack, it was a vulnerability on when Microsoft went down last year, and that impacted on airlines. So for about a week there was issues with flights and things like card payments not going through. So we see that sometimes as an impact of a cyber attack showing an impact on the real world then when things don't work. And I think these attacks are a vivid illustration for business and for consumers to see that a digital cyber attack has real world problems that impact in terms of then a network not being able to function. So M&S isn't able to do its online orders and online deliveries, which are now a big part of business for for retailers in the UK, and then you've also got the fact that things like logistics don't work. So we've already got a lot of pictures coming out from M&S and Co-op of empty shelves, problems keeping things stocked.
But then there's the flip side, actually. I was reading another story about M&S, the fact that if you are familiar with the yellow stickers, M&S put on their stock as it's going out, there seems to be a huge amount of stock that they're now having to shift due to this error, that they're having to discount incredibly heavily because obviously stock issues, they don't know how much they have, and therefore the dates and best before that's coming to the end.
Yeah. So this is going to be for, these businesses very often turn over a huge amount, but sometimes the amount of profit isn't necessarily massive. So I think M&S has got like 1,000 outlets in the UK and employs tens of thousands of people. But sometimes the actual, it's been turned around in recent years, but there are sometimes problems getting these big organisations to actually make an awful lot more money than they need to actually cover their own costs. So there's an awful lot of money they take in, but the running costs are that high that what's left over in terms of profit isn't massive. And in an instance like this, just where they're sort of probably having to work very hard just to keep their head above water, to have an impact like this is going to be significant. It will hit their bottom line in April and May of 2025, and that will have a fiscal drag on their financial performance for the rest of the financial year. So, these things are never well timed, but it's kind of one of the worst times for these businesses, just at a point where the UK economy as a whole is struggling. Now, it looks like the sort of information, and we've had confirmation within the last 24 hours that personal data was involved, certainly in the M&S breach. Information like names, dates of birth, telephone numbers, home address, household information, email address, and online order history have all been compromised. They'll have had to report this to the ICO. The UK National Cyber Security Centre is also involved. You have to think here that where things like online order history will have been breached, that starts to put us into the sensitive personal data category, because then we're looking at, you could have information from those orders that might reveal someone's religious beliefs in terms of the diet they might have and the things they might order. It might reveal disabilities from the dietary requirements that they have. So we're looking at a lot of information here, and quite rich information that would allow for profiling, that would allow for that personal data to then be used to open fake profiles in someone's name. So even though they're saying, oh, no payment information was breached, well, doesn't matter. The information is still of value to hackers and will probably lead further down the line, potentially, to enforcement from the ICO, depending what other security measures were in place.
I think it's worth mentioning as well, specifically in terms of Co-op. Co-op are not just, your corner shop. Don't forget, Co-op have funeral services, they have financial planning services, they have banking services, all of which, obviously it's not confirmed, but these are also affected within the story. Yeah. And so going back to what you were just saying, Peter, about highly sensitive data, if you've got funeral arrangements that are being breached, that's fairly sensitive, and obviously within its nature, it's going to be quite upsetting for an individual if they find that information online about someone that's deceased. That's not really an appropriate thing to just be able to have out there.
Exactly. So there will be significant ongoing consequences from this for all of these retailers. I think Harrods has also been targeted by the same hackers, apparently. And I think it will be, over the coming months, we'll see the true level of damage that's been caused, and it'll also be revealing in terms of how long it takes these organisations to get back on their feet again until orders aren't then being safely processed and delivered, and how long it takes for the shelves to get restocked. From speaking to people in retail, I think very often we don't appreciate as consumers how complex it now is to keep goods on shelves. We had a bit of an inkling on this when there was sort of panic buying over COVID and things went out, and logistics also were pushed by the circumstances of the pandemic and lockdowns. But the point is that we've seen that these supply chains can be disrupted comparatively easily, but that the knock-on effects can then last for quite a long time. So, as I say, some people might think, oh, it's another data breach, what does it matter? Well, it matters there in terms of the ongoing performance of these retailers.
Thanks, Peter. So I think that summarises the story nicely, but I'm sure that we will likely come back to these in the coming weeks.
Yeah.
Moving on to our next story, and we are focusing on AI and copyright. So part of this is looking at Elton John and Paul McCartney that are speaking out about their push for signatories, warning of mass theft and economic harm unless the government forces AI firms to disclose their use of copyrighted works. So this is quite an interesting story, and it's a lot of things that people want to put their 2 pence worth in. Peter, thoughts?
So the broader story here is with regards to the use of copyrighted material and indeed content created material from content creators out there by AI. Very often some of the AI engines that are out there have not, large language models, they have taken the view of let's get hold of whatever data we can, scrape the internet, train our engines, and then see what happens afterwards. And if people come after us, well, we'll deal with that. Elsewhere in the world, we've seen different ways that this is playing out. So in the United States, the New York Times is suing OpenAI, creators of ChatGPT, saying you went and trained your model on our archive of news and current affairs and everything going back over decades. You didn't ask permission, you just went ahead and used it, so they're suing them. As is the way with US litigation, that could take rather a long time to get anywhere, but it shows that if they've gone that far, it means that certainly New York Times are very upset, and if OpenAI offered to settle, they didn't offer enough for New York Times to clear off. In the meantime, other media organisations like News International have signed deals with different platforms. So I think News International signed a deal, News Group, which is the group that owns everything from the Times, Sunday Times in the UK, through to Fox and other newspapers in the US. They signed a deal worth about $400 million to license their data. I think it was to OpenAI, but it may have been to a different platform. So in that instance, they're saying, okay, you can use our stuff, but at least we'll get something in return for it. And legacy media now is sometimes struggling for revenue. So if you could get an injection of the best part of $500 million from somewhere for something that's already been done, potentially, well, you'll go ahead and do that, won't you?
Absolutely.
But this highlights the problem that increasingly authors, artists have in terms of being able to keep hold of their content. And we're talking about written content, we're talking about music, we're talking about video, we're talking about pictures, artworks, the whole gamut of human created content that can then be used to train these models. And therefore, that means that we have to be mindful of the impact here in terms of what's happening in the UK. So the government did a consultation that closed in February of this year, asking for views with regards to how it handles copyright, and there is now an argument going on with regards to some of the protections within the data brackets use and access closed brackets bill currently making its way through Parliament. This is one of the pieces of legislation that was in the King's speech that is being pushed forward by the UK Labour government.
I think it's important to recap kind of the aims of that consultation. So that's looking at boosting the trust and transparency between sectors by ensuring AI developers provide rights holders with greater clarity around how they use their material, enhancing right holders' control over whether or not their works are used to train AI models and their ability to be paid for it where they wish, and ensuring that AI developers have access to high quality material to train leading AI models in the UK and support innovation across the sector. So it's kind of a double-edged sword here, because obviously we're thinking about copyright and the individuals and creatives that are then having their data used for this, but at the same time it's important to balance that on the fact that we do not want to stifle innovation, because AI has truly blown up over the last couple of years, and it's clear that this is going to be the future of tech. It's just balancing the two and being able to find that balance.
So the point here is that within this piece of legislation, the government is proposing to change the law as it currently stands to allow AI models to take copyrighted work to develop software without permission from the content creator, unless that content creator opts out, right? So what we're looking at here is that the creative sector is then saying, well, no, and they've put together an amendment to this bill, which will be is now being debated, which they believe will strengthen copyright laws to protect the creative industry, which is valued at £126 billion in terms of its value to the British, the UK economy. Now, when this was in the Commons, government ministers threw out proposals to strengthen copyright protection. So now we're looking at the Lords trying to put them back in, and they've been supported by, as we said, Sir Paul McCartney and Sir Elton John,
Dua Lipa, Shirley Bassey,
Sir Tom Stoppard, the playwright, Richard Curtis, the film director, Serena McCullough, Florence Welch, the chief executive of Universal Music. So think of that. There's some of these big studios that our whole thing is we create content, movies.
And if you remember as well, there have been problems that we've covered in this podcast in the past with, I believe it was either last year or the year before, Universal Music Review took out all of their music from TikTok so that it can be used. And that was over copyright and AI. So we've already seen that this has had a massive impact. That impacted in terms of TikTok creators and also creators as a whole, because obviously there was some revenue.
So the position of the government, Sir Chris Bryant, Minister for Data and the Creative Industries, told the Commons when they were taking out the amendment, we, the government, agree transparency is key. We want to see more licensing of content. The government's committed itself to reporting back on transparency and other issues within 12 months, but the creative industry is saying that's not enough. So that's why they've had this amendment put together by and submitted by Baroness Kidron, who is a crossbench peer and filmmaker. So this is very much the sort of an ongoing fight that certainly the government, as is often the way, they'll probably say, well, we want to value content creators, but when you actually look at what's written in the law, it doesn't say that. And that's what's upsetting the creative industries here. They're seeing this as being an erosion of their existing rights, and the fact that it will be then far more difficult for them to retain the rights to the content they have created. And comes down to it then that in a world where we might have more and more content that's then AI generated, that AI being powered by original human created content, but the actual people responsible for that will not be properly credited and rewarded for it.
I'm sure, like you said, because of the back and forth on this, we will be covering this again for the next 3 years as this goes on, because it's not going to be the work of a moment to be able to get this legislation passed, because it will be going through many, many iterations and amendments.
It will, however, it is a part of the government's programme, so they will give it time to get it through. They will give it the resources as one part of its flagship programme, as was announced in the King's speech last year. So they'll try by hook or by crook to get it through, and if you're at the point of getting amendments put in the Lords, that's all well and good, but of course ultimately supremacy lies with the Commons. So I feel a bit more comfortable about this being something where the content creators will be protected if this was something where they'd actually got the government to agree. And at the moment, as is usually the case, the government's saying one thing but doing something a little bit different, and that's where I think there is cause for concern. I think part of the issue here as well is if we then look at the example of the online safety bill, where the government kept saying yes, we want to protect certain stakeholders. Sometimes the politicians themselves will think that they are doing the right thing, but because they don't understand the technology and they don't understand the black and white of the text that's in front of them, they think it's doing one thing and they'll vote one way for a piece of legislation that actually does something else. But you're only going to find out once the legislation's introduced. So, for example, online safety bill, we're only seeing the consequences of that in the Online Safety Act as it is now. Already passed previously, 2023. You'll only start enforcing it with Ofcom this year. So this is a part of a wider issue, I feel, around tech literacy.
Yeah.
And you can see why the content creators are concerned, because they want to make sure that their rights are protected in a world where, as you quite rightly said, this technology is developing very, very quickly. And their concern will be that the legislators simply don't understand or properly understand their concerns or the very real fears they've got with regards to the future of that creative industry.
Well, on that tune, we'll move
Sorry
on to
about
our
that.
last story. So our last story of the day is looking at a compensation company that has been fined £90,000 by the ICO.
Yeah.
And they've been fined £90,000 for making unlawful marketing calls. So the company used data collected from its website and third-party surveys to make 95,277 marketing calls, that being to show any form of consent. So in one quote that was used within that investigation, says, claimed she had information showing I might be due a refund in relation to my solar panels as the supply had gone bust, which isn't true. She knew my name. I explained I had not consented to receive such a call, which was an intrusion, and asked her to remove me from the list. So this is, again, not necessarily going into GDPR, but looking at PECA, the Privacy Electronic Communication Regulations 2003, that sort of sits alongside data protection laws. And they aim to govern, as a whole, marketing in electronic form. So we're talking about phone calls, emails, text messages, that area of marketing.
So the point here is that I think everyone is probably on the receiving end of marketing calls like this, and also the spam marketing email. You can do something about these things, as the fact that the biggest volume of enforcement we get from the ICO is PECA fines of this type, where they issue enforcement and they say, look, this is with regards to repetitive phone calls, or in some instances the spam marketing or the spam text messages. So it is worth reporting these things, particularly if you go, oh God, that's the second or third time I've had this. Well, either screenshot the email or screenshot the text, or take a note of the phone call and then drop a line to the ICO. You might say, well, they won't do anything with that. Well, no. Where they get a high volume of these recorded, and in this instance they'll have known that this particular claims farmer, there would have been a high volume of notifications from the public who are getting sick to the back teeth of being live.
Well, I think that's just it, because this is the point that I add salt into the wound, because the company actually made calls to those registered with a telephone preference service and failed to keep proper records of consent for those it was calling, as well as failing to properly disclose to people what they would be consenting to. Exactly. So it's not failing at two hurdles here, and two fairly fundamental ones at that.
Yeah. So exactly, if for example you are part of the telephone preference service, definitely rather than getting irate about it and telling your partner, oh, they keep on contacting me, well, do something about it, report it to the ICO. Because if they suddenly get hundreds or thousands of notifications, then they will have their investigators will then say, well, look, this is clearly a pattern of behaviour being evidenced by the information the public are giving us, and we have to do something about it. And then this is where the law works, and you do get the enforcement. So we're finishing on a nice positive story, folks.
There we go. We like that. So that was our last discussion of the episode. And if you have any questions about what we have talked about today, please feel free to email us at admin@digitallawuk.com. A summary of today's stories will be available on our website, as well as the links to the original stories, which contain more information. And if you'd like to hear more from us, including information about subscriber-only podcasts, webinars, and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. A big thank you to Anson Evaluate for helping to produce this podcast. And please feel free to leave us a review. Thank you for listening, and we hope to see you again next week.